Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Hull and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning.
Hello, Suzana.
Hi there, Ian. How are you today?
I'm fantastic, and you are doing well? Better than the last time I was with you?
Yes, that's right. Just marginally better. Thank you.
Incrementally. Well, today we wanted to just follow up on two other topic areas that were sort of flashpoints or hot topics of our recent seminar that we conducted at the Law Society here in Toronto on estate accounting. And we've received some emails and feedback since the program as well. The two topics are, one is the nature and extent of an audit that might occur on an estate and how we need to prepare for that in the context of a passive accounts. And the second is the question of compensation, but more importantly, what can you get compensated on and what can't you get compensated on? So let's start with the question of the audit. For those of us who are practicing law in the area of estates, some of us would have been involved in the days up to 1978 in Ontario where you had a succession duty. And that duty was calculated on a very complex formula that ultimately resulted in tremendous amount of time and effort for the government, who would then, of the day, would audit those. You would file your for probate, and you would file your succession duty tax to be paid. They called it a duty. That was abolished because of the cumbersome nature of it. Recently in Ontario, though, and between now and recently, we really haven't had any meaningful audit of when someone files for probate. What is the value of the estate? We write it down and we get it verified by our client as to the value, and that's it. Our underlying documents should exist in the file, but we almost have they've never been audited. Mm-hmm. Recently, the Ontario government has announced that they're going to upgrade the audit process a little bit and allow for at least part of the Ministry of Revenue to be available to do audits on estates. And I think that's a crucial element of any passive accounts, and what we talked about yesterday as well.
And when we talk about why that matters, I think ultimately when we're looking at opening balances for the assets of an estate, we're relying on someone having told us what those values are and verifying them with, the appropriate appraisals, if it's real estate, for instance, or, shares of a corporation that is being valued by people who know what they're doing and who are, basically experts at what they do, so that at the end of the day, when we are audited and we have to sort of back up our numbers, we've got the documentation there to do that.
And those valuations are crucial because ultimately the accounts that are passed have to reflect the actual value that we applied for probate for, because that's our starting balance. But also, things like real estate need qualified AAIC, proper appraisals behind them. We haven't gone through any audits here in Ontario yet, but we would expect that they would want to, if they audited an estate, the Ministry of Revenue audited an estate, they'd want to look at historic tax returns. What values did we say these assets were to CRA? And it's two governing authorities, right? We're applying for probate and saying a real estate property is worth $500,000. We might be applying for CRA and saying it's worth something different for tax purposes.
Right. And I think that what we'll probably see is that those two values are going to become much more similar, if not the same, as a result of this process, so that if things are being valued at a value for the date of death, gains or losses on those assets, as the case may be, are going to be reflected in the ultimate tax returns, and they're going to be very correlated if people want to avoid having the fear of an audit.
And I think we're just learning about how far and what the Ontario government's going to do on it, but there are lots of jurisdictions that have an audit mechanism to the probate, and with the enhanced values of the estates passing on, I think that's going to be much more closely scrutinized. All right, so the last topic that we talked about at some length of the program, but we've been getting a lot of feedback on, is the question of executors' compensation and power of attorney compensation, because in Ontario it's slightly different. But let's talk a little bit about what the concept is and what were some of the issues raised at the seminar.
Well, Ian, there's an interesting distinction between, the amount that an attorney for property or a guardian would be entitled to at the end of an accounting period, and that's usually 3% and 1% for a care and management fee annually. And then an executor, on the other hand, is going to be entitled to about 2.5% on all of the assets that come into the estate, 2.5% on all of the assets that are paid out of the estate, and then 2/5 of 1% as an annual care and management fee. So we're starting with different numbers just based on what kind of jobs are being done, and then seeing how it is that we can sort of, when you're acting for an executor, trying to make that a number as high as possible, and when you're acting for beneficiaries, not surprisingly, trying to reduce that amount as much as possible.
So we've got sort of this capital in and capital out, or ins and outs we call them, and if you're acting for an attorney, you get 3 in and 3 out with a little higher care and management, and as an executor, typically the rule of thumb is 2.5 in and 2.5 out with a little lower care and management fee.
And one of the great issues that brought about a lot of discussion at our program yesterday was what happens when you're wearing both hats. When you are the power of attorney for someone who then subsequently dies and you're the named executor, does that mean you get both the 3% in and out on the one hand and then the 2.5 in and out on the other hand?
Well, it's a very good question, and I mean that essentially would mean that you'd take 11% of the assets, and that may be too high for some judges, and it depends on the circumstances and what you've done, obviously. The other component that was a great deal of discussion on was what you can actually claim compensation on. Well, we've described it globally as in and out. And sometimes you'll roughly say about 5% of the estate or about 6% of the estate. Just to fine-tune that a little bit, there are, though, assets and there are transactions within the process that you can't get compensation on, correct?
Right. And you can imagine that we're just talking about, certainly from an executor's perspective, these rules of thumb, the 2.5 in and out. That also gets tempered with some case law factors that come out of the cases that the judges say, you can't just say it's always going to be a global 5%. It may be less because, and I'm sure you can imagine, if you've got huge estates, as we see in some cases where there's large portfolios, and you're looking at really what was the care, the time, the expertise that was applied to that asset management by the executor, it may be that just describing an arbitrary value may be too high to compensate them properly, and so it may be a reduction of that based on the size of the asset and what kind of complexities involved in actually administering it for the beneficiaries.
And that cross-check between what this sort of rough and ready percentage is against what you actually did is fundamentally supported by the vouchers, your time dockets, your efforts documented as opposed to just results. Results matter, but your time and your calculation of that time in some sort of meaningful written way is a big help, isn't it?
And we know certainly when we're looking at any audit of an estate accounting that things you were asking earlier, are there things that are clearly not compensable? And there are those kinds of things, or certainly compensable at a lower value. And just from a practice management point, we see that there's even not necessarily agreement amongst practitioners in terms of how much and what kinds of things should or should not be included.
And an easy illustration of what you can't take compensation on is that if you're a beneficiary and an executor, and you pay yourself a gift of, say, you get 5% of the estate, and you pay yourself the 5%, you're not allowed to get compensation when you pay yourself.
And the whole idea underlining that, I think, is commonsensical in the sense that you can't double dip, so to speak. You can't compensate yourself for compensating yourself.
Right.
Which makes sense.
Absolutely. All right, well, listen, we really enjoyed that program as it was back on February 21st. It gave us a good insight on some of the hot button issues and some of the red flag issues that the practitioners that we deal with were looking at, and I wanted to make sure we covered some of them in our podcasts, the last 2 podcasts. So thank you very much, Susanna.
Thank you, Ian.
We'll see everyone at the next podcast.
You have been listening to Hull and Estate and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast that you have been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull and Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.